Thank you, Mr. Chairman. I'm Zach Whiting, Policy Director and Senior Fellow at the Texas Public Policy Foundation. Unique among the witnesses that have testified so far, I am not an institution of higher education. So we do, in our research, talk more about the use of AI in higher education as well as in the K-12 setting. Would be happy to talk more about that at length later. If you or any of your would like to speak about that, we have it included in our forthcoming AI research paper, which is pretty comprehensive. My colleague David and I worked on the paper. It'll be published very soon here. We go through an overview of the history of AI, how it's used technologically, provide some case studies of how it's used in education, healthcare, criminal justice, the workforce, employment law, give an overview of how it's used, how it's being regulated at the state, local, federal and international levels. We talk about some principles and policy considerations, and we provide a glossary. So a lot of kind of a mixture of how these terms are used for the sort of the lay community, but also how these terms are used in other legislation and other laws, because as you all know, legislation can't be principles, it has to be precising language. So there are some language out there that we have. So just want to walk through kind of as a roadmap, talk about what some other states have done, some principles, some policy considerations, and then maybe highlight a few use cases, particularly in the criminal justice space, to kind of get us going. So. First off, I just want to say that the charge of what the council's doing is really important, and looking to incorporate ways of using AI to improve government function and promote the general welfare of Texans. And it is important and groundbreaking what you guys are doing. And a lot of states, much like Texas, adopted HB 2060, which formed this advisory council. In 2024, 45 states and territories introduced bills on AI. But there's not many that are doing anything on substantive use of AI in state government. Sort of a cursory glance of what I looked at, Professor Greenberg mentioned it, was the NCSL tracker. I counted about 5 bills that have actually been enacted into law that speak to substantive use of AI in state government. One of them was California, which is codifying an executive order. And I'm biased as a former lawmaker. I think legislatures, as much as possible, should decide these questions for the state of Texas broadly. So I'll give California as much credit as I can for doing that. Hawaii authorized the use of AI for wildfire detection, and Maryland created a governor subcabinet to develop standards for use in government. 2 of the bills I'll talk about later that kind of tie into how it's used in the criminal justice context are 2 laws in New Hampshire and Utah. So what all of this highlights is that there is not a roadmap for Texas to follow. Sometimes it's good for policymakers to not reinvent the wheel. Sometimes the wheel has to be invented. And in this case, I think Texas has an opportunity to really lead and be positioned to be the substantive leader among the states in AI adoption in state government and policy. So my written testimony covers, I think, at length what some of the other folks that have testified on, things like principles to guide, a code of ethics and ethical conduct and stuff. So I don't want to belabor that there. But a couple points I want to drill down on is the council's charge is one of them is to consider policies necessary to protect the privacy and interests of Texans from any diminution. I think that's important. And so that Texans remain free from unfair discrimination caused or compounded by AI use in state government. And that's not hyperbole, that's in the charge. And so it's very important that you guys are taking a look at that. I want to kind of focus on some of that in my testimony right now. Our foundational guiding principle is that technology is a tool that can be used to serve humanity. It should be used to serve humanity, not the other way around. And so using AI to augment humanity is a good thing. Allowing it to surpass or replace or defeat humanity is bad. And so from that cornerstone, things like values like privacy, transparency, accountability, and compliance, those things form the foundation for good AI policy. In private sector applications, a lot of the conversation is around human-centric, risk-based approach, and I think that is something that could well apply to uses, state government uses, putting guardrails around high-risk use cases, prohibiting unacceptable use cases. I think that's a good thing to consider. Other folks that have testified have talked about, finding ways for developers and government deployers to follow, standards or codes of conduct and things like that. Those are good practices as well. I think keeping a human in the loop approach, I think, is very important, particularly in high-risk applications and where, otherwise consequential decisions are being made, particularly on the provision of government services. I think these types of decisions are ones that need sort of added scrutiny and citizen protections placed around them. And as I mentioned before, the approach, a risk-based approach, it contemplates some uses that should not be allowed to be used, and respecting privacy, civil liberties, constitutional rights, things, again, that are in the charge of the Commission, protecting against exploitation and discrimination, protecting against the misuse of granular human data, things like your facial and emotional recognitions, biometric, and then data of vulnerable populations like minors. And then I think another thing that's been mentioned a few times, and something that I view as a great threat, much like some of the previous witnesses, is taking on those sort of epistemic challenges. Those, how do we know what's true anymore? I feel like I have these conversations with my 8-year-old every day. How did you know that? When did you know that? And so I've got to go back to sort of pre-Socratic philosophy to help answer some of those questions. One example I want to highlight, and you'll have to forgive me, I missed the previous panel when you had, for example, Department of Public Safety and the like on there, but looking at potential use cases of AI in the justice system broadly. And so you've got things like an analysis of security camera and body camera footage that can be done in real time. You can redact redact characteristic blurring in videos and stuff like that. That's a very good thing to protect the rights of the accused and those that may be witnesses, but still allow that measure of transparency that the public seems to crave, or at least our TMZ culture does. You can use it for gunshot detection, dispatching first responders, and things like administrative functions, customer-facing services, and building community trust. But one of those areas that I think can have the potential to infringe on folks' fundamental rights and liberties is automated license plates readers. And so probably aware of them. You drive through one every time you go on a toll road, like I do to and from work every day. So you've got computer-controlled cameras or software that can be built into these cameras. It can track your license plate, your location, and those kinds of things. Law enforcement often uses it to help recover stolen vehicles. That's a good thing. I think the concern is if it's used as a tool for mass surveillance, concerns about warrantless collection of information, the ability of law enforcement to purchase information from private vendors as sort of an end around the Fourth Amendment. That's a concern. There was a report recently of an ALPR vendor named Flock, who provides its services to FedEx and Kaiser Permanente, and they're allegedly sharing, those private companies are sharing their information with law enforcement. So that's a concern. In our paper, I've got a few policy recommendations discreetly on that one written down, but you could, for example, consider if these vendors should be subject to the data broker registry laws, kind of an expansion of what y'all passed last session. I believe it was SB 2215, something to that effect, putting strong privacy and hygiene protections in procurement and vendor contracts, putting limits on Private, this is a big one, I think, putting limits on exchanges between law enforcement and private entities to, again, work through that, that cat's paw or the end around the Fourth Amendment. To Mr. Bash's point earlier, is one thing you could do is ban data transfers to entities that are located in or owned by hostile foreign actors. That was a subject of a committee, a House committee hearing that was held in Tyler, Texas last week that was, hacked, and Russian propaganda was shared there. So those threats are real. One of the policies that I think is really good, and this is something that the Electronic Frontier Foundation, we actually cite, it's their research, we cite it in the paper. They go through, I think it might be a couple of companies and maybe 4 or 5 jurisdictions, the retention limits that they place on that. And so you have limits from, like, I think Flock itself, they might have a limit of maybe 30 days or something like that. And if it's not on a hot list, that information gets deleted. It's 60 days in another jurisdiction, but we've talked about New Hampshire here before. We're going to talk about it again. I think their limit is, I think it's 3 minutes. And so it's technologically feasible to have this stuff deleted that quickly. I think a lot of times we'll have these hearings and stuff. It's, well, it's not technologically feasible. We can't do it. They can. 3 minutes. They do it in New Hampshire. And then this was a concern we also talk about in our research. Is sometimes you have accounts that are older accounts. Somebody has left the agency or the company, and no one is. That's not, it's still an active account, but no one's using it. That's a vector for folks to get in and have access that they should not otherwise have. The Minneapolis Police Department had that case where people that should not be having access to ALPR information were accessing it. So I think that's a concern. One other just example I'll throw in there real quick, since I have a captive audience until you shut my mic off, but is in the court system. And so I get there may be some sort of separation of powers questions to consider here, but you have lawyers, litigants, judges are not sure how to incorporate this technology into the judicial process, if at all. And so Chief Justice Roberts, for example, in his State of the Court publication, I think it was at the end of 2023, urged the judiciary to proceed with caution and humility, and I think that's a good thing. I believe it was Dr. Schaefer mentioned that we sort of see AI as this shiny new thing, but this is, I think he called it maybe like the 3rd generation or the 3rd iteration of it, and maybe it's here to stay. So that was an interesting point. But you've had in other jurisdictions, in New York, for example, lawyers have been sanctioned for citing fake cases in briefs. There was a Washington State judge that did not admit evidence of an AI enhanced video, and that was in a triple murder case that's considered a first of its kind. So these are the types of questions that you have. And there was a federal, it's like the U.S. Judicial Commission's Federal Evidence Advisory Committee or some long name like that. A group of judges, they questioned, like, I don't even know that we need to do this at all. We think we have the tools. And so you have some that are saying you need a comprehensive approach, some that are saying, well, as judges, we should be able to do this on a case-by-case basis. You kind of get into these sort of, maybe, I don't know if this is too bold to say, sort of fundamental due process questions of, if you are deciding these things on a case-by-case basis, on a court-by-court basis, and you have, for example, questions of admissibility in a triple murder case, do we want these cases decided on a case-by-case basis, or would legislative guidance be helpful? Or we can just wait till the case gets to the Texas Supreme Court and decide it then. So I again tend to lean towards the latter, having a level playing field that litigants and judges and lawyers know going in. I mentioned before there were 2 state laws that I wanted to mention that I think go substantively more into the use of AI in state government, and they do apply in this sort of justice space. First, Utah. They generally prohibit and limit the sole reliance on an algorithm or a risk assessment score in determinations about pretrial release, diversion, sentencing, and parole. And then, once again, New Hampshire, the state of the day here, is they have a law that prohibits state agencies from using AI to manipulate, discriminate against, or surveil members of the public. And specifically, this is one of those common things we hear is making sure that there's disclosure. If that an agency gives disclosure that you're interacting with an AI system, that seems pretty basic. Taking it one step forward from a sort of consumer approach would be notice and perhaps consent or affirmative consent. That's something to consider. The New Hampshire law also looks if there's a recommendation or a decision that the system would make that they say cannot be reversed. It's not exactly clear to me what it is that can't be, something that can't be reversed, but if there is something that falls under that, it has to be reviewed by a human with sort of the appropriate responsibility level. And they generally list those things that would otherwise be in the categories of high risk. So limitations on rights and freedoms, biometric information, critical infrastructure, law enforcement actions. And then the final thing that I'll say is that they also prohibit some use cases. They prohibit it if you would classify persons in a certain way based on behavior or socioeconomic characteristics that would result in unlawful discrimination. You can't use it for real-time biometric surveillance, facial warrants, and facial recognition without a warrant. And then finally, and we hope that government wouldn't be doing this in the first place, but just to be safe, you cannot use deepfakes in a deceptive or malicious way. So sometimes we have to spell those things out for folks. That's the end of my prepared remarks. You guys had a lot of great questions earlier. Happy to answer any questions that you have now. We appreciate the opportunity to testify. We appreciate being part of this stakeholder process as you look to how to use and incorporate AI into state government services. And we also look forward to participating more as you consider how AI should be regulated at a broader private scale level.